Your Lordships again, right at the top of the page, refer to Article 17, Sub-Article 2 of the Constitution, and point out that morality is one of its features, because the word integrity means moral soundness. With great respect to that's not a major point over here, proceed from it. My lord, integrity in the context of both Article 62 and Article 17 of the Constitution is not used in the sense of moral integrity. Integrity of Pakistan is not the moral integrity of Pakistan, it is the wholeness of Pakistan. A threat to the integrity of Pakistan is not a threat to the morality of Pakistan. That is separately dealt with. When we talk in the context of the individual morality, that he's a person, man of integrity, we mean he's a man with a good degree of morality. When we say the integrity of the country is threatened, we don't talk about the morality of the country being threatened. We talk about the wholeness of the country being threatened. That's the country being threatened. That's the second meaning of the word. But my lord, moving away from that, if your lordship takes a look at page 435.
You are saying the words integrity has been given a
moral connotation.
A meaning which is not permissible by the English language.
My lord, yes. Because the English language uses the word morality in two senses, and context, as your lordship.
Morality is a different word, integrity is a different word.
And my lord,
you may have integrity and no morality, and probably vice versa.
Yeah.
I don't know.
And my lord, in some of the dictionaries, for instance, Oxford Concise uses the word integrity in both senses. Morality is the first sense, and wholeness is the second. So your lordship will always have to look at the context.
Naturally.
And when it says
in a marriage context, integrity would include morality. In a country's concept, it may not.
In the country's context, when it says a threat to the integrity of Pakistan, means it's a threat to the wholeness of Pakistan.
Also, we have to see the words in context,
yes.
Interest of sovereignty or integrity of Pakistan.
Yes, my lord. So the context is everything. My lord, then when your lordship turns to page 435, paragraph 22, the principle of interpretation of constitution are correctly.
This portion, Samula Baloch, is taking from somewhere else, or it's enumerating itself?
The one which 434, my lord, they refer to the earlier judgments of the Supreme Court in Muhammad Nawaz Sharif and Benazir Bhutto,
where morality was used in the context of integrity.
My lord, but there your lordship will see, if your lordship turns to page 433. These last two lines, these requirements are implicit in the expression in the interest of the sovereignty or integrity of Pakistan.
They don't use it in that context.
Yes, my lord.
Okay.
And if we move to page 435, the principle that constitution must be interpreted as a whole is correctly identified. And then if your lordship turns to paragraph 23, a reference is made to Article 17 and Article 62 of the Constitution. In the last lines, your lordship will see that there's a reference to the Islamic values in society. And if your lordship turns to page 436, in the middle of the opening paragraph of 436, where a declaration made by a court of law against a candidate for election warrants a conclusion of his misrepresentation, dishonesty, breach of trust, fraud, cheating, lack of fiduciary duty, conflict of interest, deception, dishonest misappropriation to be derived from such a verdict, then it stands to reason that the consequential incapacity imposed upon the candidate for election should last for as long as the declaration is in force. This result follows as a rational consequence of the judicial declaration and from the lack of any time period of incapacity of the candidate being laid down in Article 62(1)(f) of the Constitution. In other words, if the declaration by the court has attained finality, the embargo under Article 62(1)(f) of the Constitution acquires permanent effect. The foregoing aspect of Article 62(1)(f) of the Constitution do not encumber but regulate the fundamental right of political association and action under Article 17, paragraph 2 of the Constitution, and then the last 3 lines of this paragraph. Consequently, a valid declaration by the court would involve the breach of a legal duty or obligation owed by the candidate for election to another person, or the violation of the latter's legal right or privilege. Then a paragraph 25, if your lordship may see the last 4 lines on page 437. Because here their lordships identify what kind of declaration they are envisaging. Therefore, the consequence of permanent nature, that is incapacity, following a final and binding decree of a court of civil jurisdiction, is the ordinary and lawful outcome of civil litigation.
So Samiullah Baloch actually clarifies what declaration we're talking about. It's arising out of a civil jurisdiction, and dealing with civil disputes of 2 parties.
Yes, my lord. And therefore, my lord, if they had not, their lordships had not observed that, the disconnect between 62 and 63 was impossible. Because if this was a declaration by a criminal court convicting someone,
it means then a decree must be keeping in view Article 62 in mind.
that is what they envisage, as your lordship
Or it
sees.
can be when a person is applying for the election, at that time Article 62 comes.
Yes, my lord. Because your lordship see, they say
A
that.
prior decree can be.
Yes, they say that, my lord, in paragraph 26, if your lordship sees the quotation mark where 63 is reproduced, and 63H in particular, after that say, we have already observed that a conclusion about a judgment debtor having character failings specified in Article 62(1)(f) of the Constitution that emanate or can be derived from a final judicial declaration would cause the permanent incapacity of a candidate for elected office. Again, declaration of a civil nature. And if your lordship turns the page, your lordship will see paragraph 29 on page 441. Under Article 62(1)(f) of the Constitution, the judicial declaration by a court of civil jurisdiction against a candidate for election to Parliament would adjudicate misconduct of the candidate that has not resulted in his criminal conviction and sentence for more than 2 years by the competent court. Accordingly, we now consider the argument that a civil law declaration involving personal flaws mentioned in Article 62(1)(f) of the Constitution should not carry ineligibility for contesting election that is longer in duration to the disability provided in Article 63(1)(h) of the Constitution. Then they mention 63(1)(h) of the Constitution, my lord, from paragraphs 30 to virtually paragraph 32. Their lordship cite the previous case law from paragraph 33 to 35, and on page 444.
So Mr. Makhdoom, one thing that we could actually rely on Samiullah Baloch is to clear ourselves as to what declarations we're talking about. So declaration arising out of civil jurisdiction, which is an outcome of civil litigation. So several other declarations which are not arising from civil litigation or civil jurisdiction are out of the picture.
Yes, madam.
So ek to wo limit ho gaya na. So one benefit that one could probably draw from Samiullah Baloch is that the nature of that declaration is quite obvious. The second question would be, of course, the duration, but this is quite clear.
And my lord, that immediately leads to 2 submissions. Your lordship, in my research, I have not been able to find out, but your lordships may be aware better than me, that I could not find a case from any common law jurisdiction where, as a result of a civil liability and a decree of a civil court, a citizen is denied the right to exercise or the protection of a fundamental right guaranteed by the Constitution for the rest of his life. Criminally, in criminal law, it may happen.
About a banking case.
My lord.
How about a banking case?
My lord, yes.
The banking case, he's declared
My lord, yes.
debtor.
Now, the question
And
is,
the law says that if you're a debtor, till you are a debtor, your disability is there till you clear the debt
Correct, my lord. Your lordship is absolutely right, and that is why your lordship will find that insofar as that is concerned, that is reflected in Article 63 of the Constitution. And Article 63 talks about, one, the debt having been outstanding for a particular period of time, and till such time that it is paid. The moment that debt is paid, debt is removed. I was talking of a situation where a civil liability results in a person being deprived of his right forever. Because in this case, my lord, in the case of a debt, as your lordship has rightly identified, or utility bills not being paid, the moment they are paid, the debt is met, the person is eligible. In this case, what does he need?
In this case also, they say that till that decision is there, you remove that decision, you challenge that decision, set aside that decision, and your disability goes with it.
My lord, their lordship say that determination taking place from a court of final determination. Let us say that first of all, my lord, which court is capable of granting a declaration under the civil laws of the country, whether it be a Section 42 court or a Section 9 court or even an Article 199 declaration that a person is sagacious, mean, righteous, non-profligate. Because your lordships generally grant declarations about a legal title or a legal character. There is no civil court in this country which can grant that. My lord, now let's turn to the election laws. The civil code under the election law.
One question, Mr.
My lord.
The two questions rather. One is that whether the civil court has the jurisdiction to grant negative declaration, and number two, whether that court has the jurisdiction to fix the disqualification of a candidate.
My lord,
for a certain period or even for life, whether the court has power.
My lord, my submission would be that the reason why a civil court can't do that is twofold. Number one, the civil court is unable to do that because of the language of Section 42 and Section 9 and Article 199. And the second is that such an issue, when it arises particularly in the context of an election, because the issue of qualification or disqualification will only arise in the context of an election, that jurisdiction is completely ousted by Article 225 of the Constitution and the judgments of your lordship. Your lordships have said no election will be called in question. The meaning under Article 225 of the Constitution, and your lordships have said in Javed Hashmi's case that election starts from the time the Election Commission notifies the schedule till such time that a candidate is declared, returned or elected. The decisions of the election tribunal, your lordship have said in Raza Hayat Hiraj's case, cannot be called in question even in a writ petition.
Prior decree we cannot be used.
My lord,
suppose there is a prior decree before the start of election that cannot be used in the.
My lord, the prior decree will only say whether I have paid my debt or not. Now, in that case, as my lord, Mr. Justice Yahya Afridi identified, there will be a disqualification attracted under Article 63 of the Constitution. No declaration under Article 62 of sagaciousness or righteousness. My lord, which, your lordships with your vast experience in civil law, which civil court, when passing a decree, even in a banking suit, and says this money is outstanding, then goes on further to declare that this person has ceased to be sagacious, right?
So that's the question, Mr. Can you just go back, Mr. Makhdoom?
My lord.
We cannot attribute redundancy to the Constitution, even though it's quite clear that there's no such declaration that can come from any court. But we have to give meaning to because we can't just throw it out. So making an effort to giving it a meaning, this paragraph is crucial in Samiullah, that the declaration they're talking about is arising out of civil jurisdiction, inter-party litigation. So, for example, there's a case where a sale deed has been struck down as being fraudulent or forged. Now, there it has been, as a consequence, we understand that that person has committed fraud because he came up with a fraudulent sale deed. That is a bit of a construction that we have to do in order to justify this declaration given in the court. Having said that, all the other declarations which are coming in through original jurisdiction in the writ jurisdiction not arising from civil jurisdiction are out of the canvas, right? So let's first specify that the declaration we're talking about is inter partes arising out of civil litigation.
Right.
Now, in the absence of 232, we would have had to construct what is to be done. I'm just saying that legislation could, not justifying 232, but legislation could say that for the purpose of election, such a decree which is arising out of civil litigation could have a time frame for purposes of election. So the question is, can legislation put a time frame on this declaration? Could that be possible? Not the way it's worded in 232. My question to you is that, first of all, Samiullah Baloch helps us identify that which declaratory decrees we talk about, which declarations are relevant. Declarations arising out of civil jurisdiction, which are inter partes, number one. Now, could legislation, not the way it is done today, but could legislation say that this declaration will continue forever between the parties, but for the purposes of election will have a time frame?
My lord,
such a legislation is not the way it is done now in 232, but could such a legislation be possible to say that a declaration inter partes arising out of civil litigation for the purposes of election would only be for 5 years, even though between the parties it will remain forever till it is set aside, but for the purpose of election? Could such legislation take place?
my lord, that was a bit later, but may I address it right now? My lord, when your lordship looks at 62(1)(f), the constitution makers under the 18th amendment do not say that this is a declaration of a civil court. They say no declaration to the contrary by a court of law. A criminal court is as much a court of law as a civil court. Now, if your lordship reads a court of law as a court of law, a court of plenary jurisdiction, that would include courts both on the civil and criminal side which decide cases after recording of evidence. And in that, if your lordship does that, then 63 and 62 will have to be read together. There's no way one can read them differently. My lord, may I just preface this a little further?
Sure.
My lord, a question has been asked and repeatedly and my lord, Mr. Yahya Afridi asked that again yesterday. Why have two lists? Justice Hilali asked the same question again. Why have two lists? What's the difference? My lord, the two lists made perfect sense under the original 1973 Constitution. The list of qualifications was that you should be a citizen of Pakistan. For MNAs, you should be 25 years of age. For senators, you should be 30 years of age. And that is where the qualifications ended. All three were qualifications. The disqualifications were that he is of unsound mind, that he is an undischarged insolvent, or he ceases to be a citizen of Pakistan or acquires the citizenship of a foreign country. When your lordship looks at them, there is no disconnect. The qualifications are separate. The disqualifications are separate. Sorry, there is a disconnect. They deal with two different subjects. One where a qualification is acquired, one where a qualification is lost in a way, or a disqualification occurs because the person loses sanity, or the person loses citizenship, or a person becomes an undischarged insolvent. The moment the court declares that person as insolvent, then the disqualification is removed. The moment there is a declaration that the person is of sane mind, the disqualification is again removed. The moment the person acquires the citizenship of Pakistan or sheds his foreign citizenship, the disqualification is again removed. The disconnect...
एक क्वेश्चन पहले भी पूछा है पर उसमें क्लैरिटी नहीं आ रही कि 62 Article 62 applies
सुप्रीम कोर्ट में आर्टिकल 62(1)(f) की तशरीह के केस की समाअत का आगाज हुआ था जस्टिस काजी फाजीसा की सरबराही में। आगे बढ़ेंगे और आपको बताएंगे दहशतगर्दों की मुमकिना मौजूदगी की इत्तला पर दहशतगर्दों का टांक में ऑपरेशन, दहशतगर्दों और सिक्योरिटी फोर्सेस के दरमियान शदीद फायरिंग का तबादला। फायरिंग के तबादले में एक हाई वैल्यू टारगेट गुल यूस उर्फ समेत 2 दहशतगर्द हलाक हो गए। अहम खबर से आपको आगाह करेंगे, सिक्योरिटी फोर्सेस का टांक में ऑपरेशन, 2 दहशतगर्द हलाक हो चुके हैं। अहम खबर से आपको आगाह करेंगे, दहशतगर्दों की मुमकिना मौजूदगी की इत्तला पर दहशतगर्दों का टांक में ऑपरेशन। अहम खबर से आपको आगाह करेंगे, दहशतगर्दों की मुमकिना